Hello and welcome, good morning, good afternoon, good evening, wherever you may be sitting. Welcome to the second in HKA's series of energy transition events, which we are providing this evening, alongside Clyde Co, where we're going to be talking about some of the causations of disputes and claims that arise in the energy transition sector, and crucially how best to both identify those, but also how to reduce and minimise the risk of those disputes occurring through the delivery cycle. I will be talking to you first. My name is Charles Wilsoncroft. I'm a partner at HKA, and I'm joined by Mary-Ann Roth and Philip Norman, two eminently experienced partners from Clyde Co, who advise clients in all matter of things, energy and renewables related, construction and everything beyond. So I will be doing the first part of the talk looking at HKA's CRUX Insight program, which effectively is a data source that identifies causation analysis of disputes and claims in the construction energy sectors. And then Mary-Ann and Philip will be joining me to discuss how those can be best avoided, mitigated and dealt with in the delivery from a contractual and legal perspective. So, of course, the energy transition is a very broad topic, and when one discusses energy transition, there are many things that fall into that category, and it's rather than a sector, it's a categorization or a mix of different sectors. And as we are probably all aware of, people on this call, there are all sorts of things that fall into the energy transition. So, for example, we have developed and developing renewable energies, for example, offshore and onshore wind, solar projects, hydro, tidal, biofuel, and energy from waste. There are also considerations, very important considerations, in respect of transmission of the new energy sources, especially from offshore sources. Energy efficiency is a keen issue in the driver of the energy transition. And also there are new technologies, especially in the generation and use of energy, so including floating offshore wind, where offshore wind can be put into deeper water, having a much larger scope of where those sites can be set up. Carbon capture and storage, generally of existing processes and existing energy generation sites. Hydrogen, which is the talk of the town very much, and very much the future, or certainly the forecast future at the moment, both the generation of that hydrogen and the use thereof. Storage, so energy storage, so battery storage or pump storage is also in very steep ascendancy at the moment. And also part of the energy transition movement or story is the usage of existing technologies, or adapting existing other fossil fuels, gas especially, which will still be part of the mix for many years to come, several years to come, and also nuclear, not just the large scale nuclear that has been put in place, but also the conversation about small to medium reactors is back on the conversation at the moment, which goes to both the generation of electricity, but also the generation of hydrogen. So there's a big mix of topics and conversations going on in the energy transition at the moment, and of course they're huge growth areas. So we know that there's planned to be 23 billion, for example, dollars of startup hydrogen investment in 2025 alone. There's 10 billion UK and United States carbon capture and storage project currently under development. We know that the offshore wind market in the UK is very much looking to accelerate, with a 400% increase up to 2030, up to a 40 gigawatt generating capacity, which is a huge increase over the next 9 years. Also in that mix is 2 gigawatts of floating offshore wind, and there's going to be more investment, not just in the UK, but in other European nations in respect of offshore wind, floating offshore wind. The first key development that's been commissioned in Portugal, and the USA is seeing a steep increase, not least with the Biden administration coming in and very much putting their shoulder behind the development of renewables. But there's a stated projection to get to 20 gigawatts over the same period up to 2030 and beyond. I'm sure we're all aware of the developments that are being done in the eastern side of the eastern seaboard of the States at the moment. So one of the key considerations with the energy transition story is that there's a big combination of utilising existing infrastructure and utilities, establishing and meteoric growth of this well-known renewable technologies, for example, offshore wind, and also the added dimension of these new technologies coming in. And what that does, it creates a very interesting mix in respect of contractual relationships, funding, risk profiles, new players to the energy market, new players to the construction market, maybe companies that have previously been involved in traditional markets, so traditional energy generation or oil and gas markets, and making that movement themselves into the energy transition areas. On top of that, as I said, we have new players coming in, new funders coming in. Companies and shareholders are looking to invest more and more in energy transition initiatives. So there's a right mix of a whole varied swirl of technologies, scalability, newcomers and funding, which then means we've got a very different contracting landscape to that which we've had established over the last 10, 20, 30, 40, 50 years, which is very well understood. The risk profiles between companies, although maybe not always correctly allocated, are reasonably well understood, but now we've got this new horizon, we've got these new issues coming up, which very much put a different slant on how contracts are being issued, how work is being packaged, and how risk is understood and dealt with. We know that more than 90% of major global projects are over budget to varying degrees, and as we know, as I said, because the markets that come with energy transition are very much varied, the risk profiles and causations need to be properly understood. And to understand causation for being able to better identify and manage risks going forwards and to better allocate and price for those risks going forward in contracting models, we at HKA have developed our CRUX Insight program, which effectively takes claims and dispute causation from our wealth of claims and dispute work that we've done over the last 40 odd years in over 1,100 projects over 88 countries, $1.8 trillion worth of capital works. So there's a big data source there in respect of causations of claims and disputes in contracts. We've collated that data, we've created this database called CRUX, and we can then analyse that, looking region for region, sector for sector, to then identify where causations are in certain sectors, industrial sectors. We can then use that going forwards to better identify, to better plan for, better price for, and mitigate for risks as they transpire. So some of the information we have on renewables in our CRUX data, you can see on the left are two pie charts that show the splits of, proportional splits of the kind of projects that we have renewable CRUX data for, predominantly in Europe with a lot of offshore wind and hydro schemes, and also a lot in the Americas, a lot of onshore wind and a lot of solar schemes over there. The bottom left wheel shows the split between the different renewable subsectors, and interestingly, and this is what kind of makes people's ears prick up, is that the table on the right, that is a bar chart that shows for those different kinds of renewable subsectors, so everything from offshore wind through to biofuel, the proportional average cost claimed over and above the original contract value and the proportional EOT claimed over and above the original contract period varies quite significantly between the types of renewable projects, and we can see that there are some significant numbers. So for example, with solar, we've got nearly 100% on average EOT claim from the original contract period. Again, offshore wind into the 60+%, offshore wind over 50% claim value more than the original contract price. Hydro schemes, as we can see, are very, very highly priced due to some significant issues that we'll have a quick look at. So just having a look at some of the data that sits behind the CRUX analysis that we've got for certain renewable subsectors. And what we see, interestingly, as one might expect, is that the causation data for different subsectors changes depending on the subsector. So when we look at hydro schemes, we see that the primary cause of disputes and causations is management failure by the contractors by a significant amount. So 25% of claims and disputes under hydro schemes taken from our data actually is rooted as the primary causation being the management failure of the contractors, which is similar to solar, which is, has between 20 and 25%, again, management failure by the contractors. What we see is an increase in design issues in respect of solar schemes. So that has the same prevalence of primary causation for solar schemes, whereas design for hydro schemes is right down into 7th place at only 5% of primary causations. So what this does, it starts to unwrap and starts to unfold some of the key areas where, if we're looking at certain sectors, or indeed if we're looking at moving just from a known sector to a more innovative sector, where we can look at and where we need to look at in respect of understanding and managing and allocating risk going forward, and also potentially the procurement route or making sure that the process is set up correctly. Again, looking at onshore wind and offshore wind, another two subsectors of renewables that we have data for. Onshore wind, by far in excess of everything else, physical conditions. So this is unforeseen physical conditions predominantly, so ground conditions, that sort of thing. Up to 45% of primary causation of onshore wind farm jobs, which identifies that of onshore wind farm jobs that we've worked on, that what needs to be looked at, and perhaps what hasn't been sufficiently addressed leading into the procurement of that project, is the proper site investigation. How has the risk of ground conditions been taken on board? You would expect perhaps that most of these contracts have been not done on an EPC where the client's taken on board the risk of ground conditions, and hence that's why the prevalence of claims in that way come in. So employers can look at this and say, well, actually, yeah, we know that if we go down a certain contracting model, there's a very good chance that we're going to get claims of ground conditions against us. Again, you'll notice that management failure still is coming up very, very high, second ranked on onshore wind, and then also things like skill works issues and also client management failure. Now, interestingly, we have something similar offshore wind. Again, that contractor's management failure is coming out as top causation again. This is primary causation. Secondly is client's management failure. So, in offshore wind, there does seem to be a significant prevalence of management failure both on the contractor and client side, which suggests that there's an issue of either level of resourcing between the contractor and the client, or perhaps skill and expertise, because even though there is a lot of experience in the offshore wind market in Northern Europe, it's still relatively new, and especially with the scalability of ramping up the outputs that has been looked at from the UK, then it could identify that there's going to be a bit of a skills gap when it comes to management teams' capabilities and abilities to properly administer the contracts that are being entered into. Again, we have the issue of skills works issues, which I think maybe dovetails in quite closely with that kind of general principle, and also issues with contracts in offshore wind. So contract interpretation, which is joint with skills works issues for offshore wind as being the key primary causations for disputes in those sectors. So one of the things we're able to do with CRUX, and one of the kind of value or benefits that parties can have in utilising the data, is by comparing, almost not like for like, but somewhat comparable sectors between, say, oil and gas and renewables, because there are a lot of the oil and gas majors, oil and gas contractors who are making that transition from the traditional oil and gas markets into the renewable markets for understandable reasons. Now, obviously, one of the things about that is that it makes sense in a lot of ways. You have, a lot of the outline technology is the same. You use the same large vessels, for example, with offshore wind as you do for offshore and gas largely. You know, the idea of transporting and installing a jacket foundation is very similar between an oil and gas project as it is for an offshore wind project. So there are lots of synergies in respect of the technical capabilities. You know, the offshore marine contractors who do a lot of oil and gas work, they have the infrastructure, they understand what they can and can't do out of certain ports at certain times, they understand the weather, all these constraints and issues, they get all that, so it makes sense to make that transition. But of course, as I mentioned before, the funding and contracting models between an oil and gas project are very different from an offshore wind project, and therefore the commercial balance, the risks, and also the amount of movement that clients may have to deal with things, or be able to absorb delays to projects, are very different under an oil and gas project as they are from a renewables project. So it's quite helpful and quite handy to use data to compare comparable parts of sectors to then identify, like I said, where focus should be given in respect of risk allocation and mitigation and management. And we can see that just having a look, generally oil and gas compared to renewables, or oil and gas, and these bar charts show the green are primary causations, and we also have secondary causations, so contributory factors. So these bar charts show the comparative analysis between oil and gas generally and renewables generally. And what they show is that for oil and gas, the key issues really are design, changes in scope, which is somewhat related to design, management failures by the contractor again, and management failures by the client. And those four key causation types very much outweigh the other causations, the smaller ones. When you look at renewables, we see that actually certain different aspects come up. So physical aspects come up, so physical unforeseen physical conditions, that sort of issue very much comes to the fray, much more so than oil and gas projects. Management failure, well, we already identified that on looking at the renewable subsectors. Management failure by the contractor generally comes out at rank 1 or 2 across the subsectors, and indeed it comes out as the highest overall issue in respect to the renewables. And what I found is quite interesting to look at is comparing, going back to the discussion I just had about the idea that there are lots of operators currently in the oil and gas market who are making that transition into the renewables market for understandable reasons. Well, there's obviously quite a lot of parallel between oil and gas offshore and offshore wind. So what does it look like? What are the differences between the causations? So these two charts show quite neatly a side-by-side comparison of how those two industry sectors stack up. So with offshore primary, so this is oil and gas offshore, sorry. So design is by far and out and away the biggest issue. Management failure by the contractor still comes in at number 2, and changing scope, which of course you tend to get under EPC contracts. Oil and gas projects are very, very commonly EPC contracts. And from our analysis, because we're able to look at it on a procurement route analysis as well, and when you look at the EPC analysis, changing scope very much comes out as being the main issue. So you have these kind of top 3 causations in oil and gas offshore, being design, contractor management failure, and changing scope. Whereas when you look at offshore wind, again, we see this management failure by contractors by far and away. 25% of all primary causation of claims and disputes are down to, in accordance with the data, is down to failure by the contractor to properly manage the contract, which I think is really quite telling and is really significant. And this is the sort of thing that both employers and contractors in this market, especially those making the move from oil and gas into renewables, need to take a close look at and realise that actually, clearly, there are issues in the management teams of the contractors and to some degree the clients, because as we see, the second issue in offshore wind is client management failure. So both parties need to have a look and understand and properly resource, either in level of resource or expertise of resource, or I would argue a mixture of both, in order to minimise and mitigate the existence or the occurrence of claims and disputes in offshore wind projects going forwards. So it's quite a big sea change, I think, from, for say an offshore EPCI contractor to change the way they deliver things, to change the way they work, to recognise this clear differential in causation. And then we also have skills work issues and contracts, as I mentioned before, being key issues in the offshore wind market. As could be expected, the issue of skills, it is a growth area. There's not a huge pool of people with the skills and expertise in that area. There is a good pool of people, but as we all know, that pool of people, there's not very much slack in that pool of people. And of course, when people come in from different sectors, then all of a sudden you've got that learning curve that goes with those. And also contracts interpretation. Clearly there's something that needs to be looked at in that respect. And just to kind of almost wrap this up, again, this is quite a good slide that just shows the difference between oil and gas. And this is all oil and gas compared to all renewables. So it's just a bit of a snapshot just to give a bit of a taster. But what this shows is that actually of all claims and disputes that we've been involved in, that have gone through and are in our CRUX data, for oil and gas, there's 44% that weren't settled and led to a full dispute process, which, okay, seems like a reasonable figure, but then you look at that compared to the renewables market, and that jumps up to 61% not settled. Now, of course, that's just a quick snapshot in time. There's a lot of digging you can do into the data and find out more from that. But I think that's really, really quite telling to say, look, the fact of the matter is, as things stand, as a percentage, it appears that you're much more likely to get into a formal dispute process with a renewable project than you are with an oil and gas project. Now, that's quite possibly largely to do with the commercial framework and setup difference between the oil and gas market and the renewables market. I mean, for example, taking a few actual real world examples, one of the conversations I most frequently have with our clients, especially with our offshore contractor clients who are making the move and to do more and more renewables, is that, well, under oil and gas jobs, you don't tend to get hit with LDs that often, whereas with renewables jobs, you tend to get hit with LDs an awful lot. And there's a real conversation around that, so the issue of management of the program, claims for extensions of time, and then is starting to go through that process because employers are withholding, taking over, they are removing, withholding LADs, and contractors are then having to fight a little bit harder than they would have done under a traditional oil and gas project to get that. Now, that's due to a whole range of factors, and I'm sure Mary-Anne and Philip will maybe touch on that if they want, but it's a very common conversation I'm having at the moment. I'll just put it that way and leave it at that. So just to wrap up, probably the key issues and the key points that we've identified through looking at the CRUX analysis, and I do say that that's a very high level look we've just looked at. It's a bit of a whistle-stop tour, as I'm sure you appreciate, but the key recurring causations of claims and disputes in the renewable sector that we've seen really are, I mean, the contractor management failure consistently comes out at either the top or second place of all of the renewable subsectors. Management failure by the client also comes out very heavily, especially in the offshore wind sector. Skills and resources, clearly there's a skills gap in renewables generally, and if we've got any chance as an industry of hitting the kind of the almost explosive targets that we're looking at, pun intended, these targets that we're looking at in respect of huge scale increase, especially in offshore wind and the new technology in hydrogen, and also all the infrastructure and transmission that goes around it, there are serious skills issues there that I think we, as an industry, as a sector, that need to be addressed, and that are likely to, if they're not addressed, will lead to more causations of disputes. Contract interpretation is one. And this is going to be even more prevalent, I think, the more and more new technologies we have come in. You know, whenever you have new developing technologies pushing, you know, the state of the art, then you've got issues over, well, where are the boundaries between the liabilities? You know, who takes responsibility for this? Where does the design liability stop? You know, so there are all sorts of issues that come around that evidently will grow, I believe, and also issues with the design, which is an inherent issue that we see running through pretty much every sector that we work in as key causations. So I'm conscious that I've rattled on a little bit there. So Marianne and Philip, I'm sorry if I've overrun the touch, and I will now pass over to you two. Thanks very much.
Thanks, Charles. Always important to overrun a little bit in a construction discussion. So I'm Marianne Roth. I'm a partner at Clyde Co. I specialise in construction disputes, particularly in the energy sector. And together with Philip, my partner, we're going to be building on the discussion and the really interesting data actually that Charles has just shared with us. The two words management failure seem to crop up rather a lot. And rather seamlessly, we're going to be touching on that, actually looking at, in fact, it'd be interesting, Charles, really to see what sorts of management failures those were. But I think a lot of the things that go wrong start from a misunderstanding of the contract or a kind of misalignment between the contract and the parties' expectations. So that may be certainly something that we can look at in terms of helping to avoid disputes. We're also going to touch a little bit on how to deal with disputes if they do happen at the end of this discussion. The presentation that Charles has just given us talked about clean energy projects generally. Most of the examples we're going to give are going to relate to offshore wind just because they are big and complex sectors, but a lot of the comments also will be transferable to other clean energy projects. So hopefully the information that we give you will spread across both. We're going to start by picking out some of the key contract risks. Again, a lot of those have already been touched on and flagged by Charles, but what we're going to try and do is give you a few practical hints and tips as to how you can mitigate and, if possible, avoid those. So I'm going to hand over to Philip to kick off that part of the discussion.
Hi everyone, I'm Philip Norman. I'm one of the partners at Clyde Co, and I've been practicing essentially dispute resolution in energy and broader construction for the last 27 years. And it was very interesting hearing what Charles had to say and the data that came out of the CRUX analysis. And it absolutely mirrors what I think Marianne and I see going on in the marketplace. And it's certainly one of those situations where you see that there are things that can be done to mitigate against those risks. And when you see that 61% of disputes or claims arising in renewables are not settled and go to formal dispute, I mean, that's a pretty big percentage. So there are things that ought to be done. So what we've discussed today is some of those strategies, but also remembering that what we say translates not only to offshore wind, but across the renewable space. And some of it is brought about by experiences. And I guess what we see, what again we've seen from Charles's presentation, from the fact that, you know, things are moving forward, and therefore you've still got some baggage from the previous way that energy projects were developed. So I guess the biggest way to mitigate risk is get your contracts right. And we would say that as lawyers, but inevitably, as hard as we work and as many lawyers as there are in the world, human ingenuity and what happens on sites always causes difficulties to arise. And so, look, what do we do? There are many standard form contracts, and from those standard form contracts, most projects are developed. And it's really important because those standard form contracts show best international or domestic practice. They have pretty much the standard terms and risk allocation that one might accept. And more often than not, what they try to do is allocate risk to the party that is best suited to manage that. But life isn't that simple. You know, 61% of disputes going, 61% of claims going to formal dispute shows that. And partly that is because what parties do is they don't accept standard forms as written and just fill in the blanks in terms of, you know, contract price, contract duration, what the liquidated damages might be. They start amending, and of course they start amending because there are idiosyncrasies both to the type of project, the type of management of a project. For example, you might be in a country where it's very important that the procurer is able to comply with its auditing requirements. Therefore, payment applications have to be done in a certain way which aren't envisaged in the standard form or different from the standard form. So you see people messing around with that, and as soon as that happens, inevitably there's going to be a disconnect between the conditions of contract at the front and the very, very important annexes or schedules that you see at the back. You know, specifications are updated and negotiated, information exchange. So what is one party to rely upon, and contract price, how payment is made. So all of these things get changed as one develops and tries to use those standard forms in a more bespoke type matter. But that's where we see the problems, where the front end doesn't match the back end because any change hasn't been translated all the way through the contract, causes difficulties. And you know, we have seen a lot of examples of this, and more recently in the offshore wind sector, we've seen that where there is an allocation of design responsibility, courts and tribunals have been trying to battle to make sense of, you know, what the front of the contract says and the inconsistency with the back end of the contract, because they seem to be, in often cases, pulling in different directions. So trying to achieve consistency is sort of paramount importance, because once you've got that, your risk profile starts going down. We then look at another risk, which is the governing law, especially when you're dealing with international contracts. Look, if you're in the UK, you choose a governing law. England, for example, you know broadly that is your background. But let's say you've got international contractors or international participants or funders of these projects, or you're working in international waters or a location. Governing law becomes very, very important because even though you have those standard form contracts as your basis, the risk allocation might be changed through implied terms of brought about by statutory provisions in the governing law. And the biggest one that seems to be missed and causes real difficulty is how one goes about interpreting contract provisions. You might think that that's a banal question because, you know, a contract is what it says it is, but many countries, and I've worked all around the world, just deal with contract interpretation in a very different way. We can't simply say, look, you give an objective meaning to the words used and you give those words their ordinary meaning, because that often isn't the way that some countries deal with interpretation. You've then got another issue, which is that where you might say in the contract, look, you have to bring a claim by X number of days, otherwise you might waive your rights to asserting that claim and obtaining either an extension of time or compensation. There might be provisions of law in the governing law which preclude that, or there might be provisions of law which say ultimately you might have agreed a liquidated damages provision or some form of contractual compensation, and that can be discounted easily. So look at the governing law and don't underestimate the importance of that. Another aspect, especially dealing internationally, is, you know, who is responsible for getting the licenses? Who is responsible for making sure that the works comply with the standards that are required in the place where the works are being carried out? So again, the standard forms that might be adopted are a good starting point, but just make sure that you track through that risk between both the front and back end, and keep a very close eye on actually what that risk profile is under the governing law. So let's look at look at some of those risks. Adverse weather is, a key issue to offshore construction works or construction works in difficult geographies, whether you're right up in the north or the south where it's incredibly cold, or you're working up in mountains, or you're working in the heat plains around the equator. And what you usually see is the program for those works are calculated against the best time to do those works weather-wise, to allow people to get in, to allow people to go out. But when you have delay events which impact upon progress, works can be pushed into unseasonal weather periods, and those then essentially compound and exaggerate delays that might have been because of weather. And so you tend to see where the disputes are, and it then starts becoming very, very difficult about who is responsible and to what proportion is their responsibility. Is it the original delay event for which a party might be responsible, or does it move on to inclement weather or whatever it might be? And so making sure things like weather risks, especially with renewable energies, whether it's hydro, offshore wind, needs to be dealt with. Other risks that we see arising are access to site and compulsory purchase. So especially again in it's easy enough, I think, in England to say, well, look, we're doing these works, everything will be set up. But once you start moving internationally, those issues become difficult, because it may be that the legislative framework in the country in which you're operating can't easily run compulsory purchase, or can't give you access to neighbouring sites. And so those are things that need to be thought about, because if you can't get to site, you might not be able to do the work. And if you can't do the work, whose responsibility is it to deal with the consequences of that? And so look, for international projects, it's really important that there is clarity about access to land, licensing, to ensure that if there has to be compulsory purchase or eminent domain issues, they're all dealt with in advance, or if not dealt with in advance, that the contractual risk for that is clearly stipulated. And then it's really interesting what Charles said about design and issues in renewables. I for a period of time, I sat as general counsel in the UK for a big engineering firm. And one of the rules that we had whenever we were getting into contracts is we wouldn't do more than four things that were new, whether it was contractual terms, whether it was working new geographies, whether it was using new technologies, whether it was accepting different levels of damages or whatever it might be. And when you're dealing with renewables, and when you're dealing with these new technologies that come out and keep updating it at such a rapid pace, you start compounding the risk. You're in a new geography, or you're in a new field, you're using new technologies, etc., and that can cause real trouble. So factor that in terms of the risks, because if you're saying there that you're going to perform, if you're now dealing with a whole lot of imponderables and areas where you haven't dealt with before, you're creating problems. So those are things I want to say. I think, Mary, if you can talk about programs and delays and those sorts of issues, and we can talk about more international stuff a bit later.
Yeah, thanks, Philip. I was going to say a few words on programming and delay, really picking up on some of the comments that you were making in relation to factors such as adverse weather or things like seabed conditions, scope changes, etc., all of which can, of course, cause delay. I mean, it could also simply be due to the fact that the project was poorly planned and programmed from the start, or that as you're going along, the programs haven't been updated to reflect reality. And that's back to perhaps what we were talking about before around management, which keeps coming up as a factor. So project contracts generally expressly provide that the contractor is entitled, as we know, to an extension of time for delays assigned in the contract as an employer's risk or as force majeure. That is reasonably clear, but we can have problems. Problems can arise where you have not expressly allocated the risk for particular delays, and that might be, for example, delay caused by breaches of contract by the employer, where that's not actually covered off correctly or fully by the contract. So an example is where perhaps the employer agrees to provide unfettered access to the installation, but there are delays caused by the employer's work on nearby installations, and they might not be events falling into the permissible delay categories under the contract, but they might delay things. So you'll then have the contractor arguing, well, I should be entitled to an extension of time because the employer has delayed me, but you'll have the employer arguing, well, no, you're not, because the delays don't fall into the categories set out in the contract. So it's a question of contractual interpretation, of course. The outcome is going to depend on the wording and the facts in each case, but that's again back to trying to think ahead to how your contract is going to deal with these things from the start. So that's one way of mitigating the risk, clarity in the drafting. And I think another way of mitigating risk really is just trying to make sure that you keep documentary evidence of the delaying event and the impact that it's had on the programme as you're going along. As arbitration or litigation counsel, we go on about evidence all the time, but it's incredibly important and makes a huge difference to success or failure in any dispute if you do end up in dispute. So I think the other thing to remember that is crucial is making sure that you accurately notify the delaying event, and do remember to check the notice provisions in the contract. Again, something that seems so obvious and simple, but is often overlooked. And you'll find that many such provisions are drafted as conditions precedent. So in other words, if you do not comply with the provisions, you may forfeit the right to pursue your EOT claim, or indeed, employer side, you may forfeit the right to reject it. So great care required there. Just while we're on the topic of delay, another challenging issue is concurrent delay. We could talk to you all day about this, probably not very excitingly, but it is a complex area and it can cause great uncertainty. Concurrent delay arises if there are two incidents, one a company risk and one a contractor risk, which have the same causative impact at the same time. In other words, one without the other would have caused the same amount of delay. And it's actually quite rare to get true concurrency, but it is a challenging issue when it arises. And if it does arise, the contractor is generally entitled to an extension of time, but no money. That's the standard English law position. But again, check your contract and think ahead as to how you want that issue to be dealt with if it does crop up. Another interesting topic in the context of clean energy and construction work is liquidated damages. And again, Charles touched on this as a challenging area potentially. As many of you will know, many contracts choose to include LD's provisions rather than relying on general damages, because it means you don't have to prove the amount of your loss. And certainly under English law, and back again to what Philip was saying about check your governing law provisions, but English law upholds liquidated damages provisions provided they are deemed not to be a penalty. So the test for penalty is now whether the remedy is disproportionate to the legitimate interest it is designed to protect, which is a bit of a mouthful and is much more complicated than the earlier definition that it has to be a genuine pre-estimate of loss, but it has now been slightly changed, although actually people are kind of assuming that the new meaning is rather similar to the old one. But that's what you need to look for as to whether it's a penalty. You'll often find people trying to challenge LDs on the basis that they are a penalty. Just remember that that issue needs to be judged at the time of contracting, so that the fact that your losses are less, in fact, than the amount of LD specified, or even that they're nil, will not of itself void the LD's clause. But you do need to, you'll find there are challenges made around that. So for example, if the actual losses are nil, and they were always going to be nil, you might want to raise questions about whether the provision is in fact a penalty, because damage was never going to be suffered. So keeping a note of how you actually calculate the level of the LDs when you draft your contract is always quite a good plan. And another thing to be really aware of is making clear what happens if the LD's provisions are held to be unenforceable. So in other words, can the company revert to general damages in those circumstances? Or if, for example, there's an exclusive remedies provision, it's quite likely that the company can't, and it needs to sort of put up and shut up, as it were. If you are in that kind of area and looking at LDs against general damages, again, watch out for liability exclusions for loss of profit, because you might find that the amount of the LDs has had built into it an element of taking account of loss of profit, whereas it's quite likely that that would be excluded from a general damages claim. So quite a lot to think about there. Programming and delay are massive causes of disputes, and I suspect strongly that they feed into Charles's management failure point that he kept referring to, so well worth keeping an eye on. I wanted to say a quick word also on design and performance obligations. Really, Philip has touched on this already, but again, a huge area of dispute from what Charles was saying. Similar levels of dispute, I think, between oil and gas and clean energy, but definitely one that runs and runs, as it were. And the key issue here is around what standard of care the contractor was required to comply with in respect of design. So is it reasonable skill and care, or is it fitness for purpose? Generally, obviously, the contractor is going to be looking for reasonable skill and care. And if fitness for purpose is the standard, then the contractor will be looking for more money on the back of that. So the real thing to look out for is not ending up with a fitness for purpose obligation by the back door. And again, Philip referred to this, but many of you will know the case of MT Hogard and E.ON, which I think was back in 2017, but worth referring to again now, which was the Robin Rig offshore wind farm. And in that case, sort of cutting a long story short, but the contractor designed the foundations to an international standard at the time. The contractor was not negligent and acted with reasonable skill and care, but there was also an obligation for the foundations to last for 20 years. So reasonable skill and care at the front, but the back end in effect imposed a fitness for purpose obligation through the 20-year service life. So that is the kind of issue that you have to really look out for, so that you're not ending up with, as I say, a fitness for purpose standard by the back door. So there are many other risks that we could touch on, but those were the key ones that we wanted to pull out, because we wanted to end with saying a few words on dispute resolution. If you do end up, despite having done what you can to manage your project well and so on, if you do end up in dispute. We wanted to touch first of all on adjudication. I'm going to talk to that, and then Philip is going to pick up at the end talking about arbitration. And the reason that I wanted to say a few words about adjudication is that if you are knowledgeable about and you've worked in the onshore construction industry in the UK and in several other jurisdictions, you will know all about adjudication, because we've had a adjudication as a statutory dispute resolution process for many years. You'll also find that standard forms of contract have introduced a contractual adjudication process too, for both in the UK and in other countries that don't have a statutory scheme. And as you will know if you've come across this before, it was aimed and is aimed at being a really quick way of resolving disputes, especially payment disputes. The point being that you get them resolved and then you carry on with the construction work. And it's a quick sort of bringing a third party in to get a quick and rapid decision. But for those of you who haven't come across adjudication before, it is a scary and brutal thing. And if you haven't worked on construction projects, or if you've exclusively worked on projects in the energy or power generation sector, where statutory adjudication is excluded, then you might well not know about it. So very quickly, as I said, you may find this coming into your contracts through the contract rather than being statutorily applied. And that certainly in relation to offshore wind projects and other similar projects. adjudication is often employed as a dispute resolution means. It's very, very quick, 28 days to 42 days, or it can be extended, but generally the whole thing is done and dusted after 42 days. Usually takes place on paper only, although the adjudicator can call meetings if he or she wants to. And it, as I said, it can be a way of resolving disputes quickly, but it can also be very adversarial between the parties and create some quite bad feeling, which is unhelpful if the project is ongoing. There are many, many procedural traps for the unwary. There's a huge body of case law all around adjudication. So it's really important that you speak with your advisors and you know how to navigate those traps. Otherwise, you're quite likely to either have an unenforceable decision or to lose your rights to challenge a decision which could otherwise be challenged. And people often find, or often refer to it as kind of rough justice, because it is so quick. You can have quite variable quality of adjudicators, so really important to try and agree an appropriately qualified and reputable adjudicator, or use a good adjudicator nominating body. And one of the most scary things about it is that it's interim binding, which means that it is binding on you until it's finally determined in court or in arbitration. And until it is overturned in court or in arbitration, then you have to pay the cash across, pay the money across, whether you like it or not. So even if it's wrong, even if the decision is wrong as a matter of fact or law, you cannot challenge it. There's some very, very narrow grounds around procedural unfairness and bias, etc. But if you don't fall within that, then you can't challenge. So I think the sort of top tip really is be aware of the risk of this. Adjudications can be launched with very, very little warning. So you could be landed with an adjudication and have to respond to it in a week or two, even for a very, very large claim. So I think watch out for the warning signs in correspondence. You know, if your counterparty starts talking about crystallized disputes or starts using aggressive language, then just watch out that adjudication is not landed on you unexpectedly. So with those words, I'm just going to hand back to Philip, who's going to say a little bit more about arbitration and other formal dispute resolution methods.
Yeah, thanks, Marianne. I mean, look, I think most of it has been said, but dispute, going back to managing risk, dispute clauses are really important, and you know, we talk about this a lot. But picking up on the points that have been made, it's really important that time is spent on that. Find the right court or arbitration seat that works for you. Make sure that they've got laws that support any dispute resolution process that you have, and have an eye for future enforceability. And just on this contractual adjudication point, where you have got a project in a country that doesn't have a legal system or legislation that is as developed as, say, England, that supports adjudication and has the legislative framework to allow rapid enforcement, think about what you might do on dispute adjudication board decisions in your arbitration agreement. It may be that you can have a well-defined short form arbitration just to enforce that adjudication decision. Another area of risk, often, especially with renewables, is because you've got so many different parties being involved, is how do you manage that interface? That's one of the issues, but if it comes to a formal dispute process, you need to be thinking about, especially if it's arbitration, how do you go about potentially joining the different parties that are involved, so that you don't have parallel and potentially inconsistent arbitrations throughout. So those are really important things to think about. And I think, look, with that, we want to give some time for questions and answers. So should we park our discussion there for the time being and hope that some questions are coming through?
I'm just going to jump in because there is a question I can pick up straight away, Charles. Sorry, I know you were going to moderate, but
That's cool.
someone's asked, does the construction act apply to offshore wind? So no, basically it doesn't. There are exceptions for a number of reasons, but there are exceptions that relate to power generation. Depending where your offshore wind farm is, it might be outside the boundaries of the UK anyway. So it doesn't apply, but to be honest, all of the offshore wind contracts I've seen have had adjudication as a contractual mechanism. So you're likely to be landed with it anyway. That's that question answered. Charles, sorry, over to you.
No, that's quite all right, Marianne, no problem at all. Yeah, I was going to say, you know, in just from my experience, the issue of dispute adjudication boards does tend to be used quite a lot in the offshore wind market. And I mean, I've had a bit of experience working with overseas contractors, European contractors, who have then been initiated into the adjudication process, and a lot of it doesn't sit very neatly with some of them. They prefer arbitration litigation because that's what they understand a bit better. But we could talk all day about the the relative merits and demerits of adjudication, of course. But yeah, there's one other question in at the moment, which is really aimed at the CRUX analysis, and that is from Richard. So by formal, I assume you're including ADR, such as mediation or adjudication, in respect of those numbers that we identified that went to formal dispute resolution. And I think that's a good point, and it's probably a bit of a loose terminology. Yes, the issue of those those percentages are matters that were not settled, so undertook some form of formal or semi-formal dispute resolution process. So yes, it could be ADR, or of course it could be arbitration litigation. If we dug into numbers, I could tell you what those splits are. But really, I mean, the idea of it was just to show the kind of, you know, the juxtaposition between oil and gas as a sector and renewables as a sector. But yeah, your point is valid, and it does incorporate non-strictly formal dispute resolution processes. So they're the two questions we have on the board. I'm also conscious that there's 2 minutes to go, and okay, thanks Richard for acknowledging that. So we've got 2 more minutes, I think, on the session. So if there are any other questions, please do drop a note in, or if we don't hear anything else, of course, you know, Marianne, Philip, myself, you've got our contact details, and if anyone does have questions that you wake up in the middle of the night thinking, God, I wish I'd answer that, then feel free to get in touch. And if I believe there's no other questions, unless Marianne and Philip, you have anything more you'd like to add. Oh, we've got some.
No, Charles, I was just going to say, your slides were extremely interesting, and I know people will want to see a copy of those, and we can certainly circulate those afterwards. We've also got some notes from the presentation that Philip and I did, which we can share also if people want to. So please, could people drop us a line if they're interested in that.
Excellent, thank you. And coming to, there was a quick question at the end. Hi, what are typical management failures, client and contractor? Well, I mean, certainly from the contractor's point of view, from the client's point of view, they are frequently issues, because just to summarize, the way I presented the data was would group together certain specific detailed causations into different kind of categories. I feel it's a better way to look at it. So some of the failures that fall into those categories are things like approvals issued late, or insufficient responses, or incorrect responses contractually to contractors' submissions, that sort of thing. And from a contractor point of view, it includes things like you know, unparticularized or spurious claims, or lack of program control, and there are a whole number of detailed causations. And in fact, what I can do, Al, and anyone else who wants, I can send you a list of all the actual detailed causations and how they group. I didn't talk about it in this particular talk because time was a bit constrained, but I can show you some slides that show the individual causations and how I've grouped them together, which might be of interest to you so I can maybe add that as another slide to what I presented when we distribute that. So hopefully that will answer your question. Great. Okay, so I think that's probably us. So Philip and Marianne, thank you very much for joining us on this session. It's been a real pleasure. And thanks everyone for joining. Obviously everyone's leaving now to get their coffee and maybe grab some food. So I think we're planning on doing a third energy transition event in the next few months, but watch your space for that. And yeah, thanks again for everyone for being involved. Appreciate it very much, and have a good day.
Thanks everyone. Bye bye.
Great, thank you. Bye bye.